and of a weapon, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, this is a under 21 UCW. I can still read you the facts if you'd like. Okay.
Alright folks, buckle up, this case opens like a legal thriller. We've got an 18-year-old, a gunshot wound, and a courtroom ready to dissect what really went down in that alley. But here's the kicker, no weapon charge, yet a shooting involved? Let's unpack that.
On March 3rd, 2025, an officer was dispatched to a shooting. The officer found the defendant in a back alleyway with a gunshot wound to his leg. The defendant had a mesh backpack in his possession at the time and was able to see that there was a black handgun inside. The caliber of the handgun matched shell casings located on the ground next to the defendant. The defendant stated that he shot the gun in self-defense at 3 black males who shot at him. Those suspects fled the scene after officers' arrival. The defendant was transported to Ben Taub Hospital where the defendant was being treated for the gunshot wound to his left femur. The defendant admitted to being...
Notice how the officer lays out the chain of evidence, the gun's caliber matching the shell casings. In courtroom terms, that's probable cause gold. But if there's no eyewitness or forensic confirmation he fired it, that raises serious doubt. Remember, possession isn't the same as use.
In the 114th Street Bounty Hunters gang and is 18 years old.
And so was it really that, did he shoot himself, or do we know that someone else shot?
We do not know. We know that the casings on scene matched the caliber of the handgun that he had, but we don't know if he had shot himself and he stated he was being shot at by other people as well, so it's unclear.
Now pause here. The defendant admits to being in a gang at just 18. That's not just background noise, it shapes how the system sees him. And fair or not, that label alone can turn victim of a shooting into suspect in a crime in seconds.
So the only allegation is that he's underage, essentially. Okay. Mr. Ibarra, I'm going to find that there's no probable cause to go forward in your case. You need to be very careful. You get but one life. You know, God forbid something happens where you have a gun and you use it, and then you end up getting charged with something. You've gotten shot in the leg now. I mean, luckily it's not somewhere else. It could be life ending. So when you hang with dogs, or when you're bad places in the middle of the night, really, do something with your life. Get into school, graduate, get some knowledge. So take a seat.
Here's where the judge flips the tone, from procedural to parental. You can almost feel the empathy under that robe. When she says, "You get but one life," she's not just warning him, she's pleading with him. Question for you, do you think judges should play this mentor role, or stick strictly to the law?
Ms. Reyes.
Yes, Reyes.
Good morning.
Ms. Reyes, you're charged with failure to stop and give information. Essentially, leaving the scene of an accident without exchanging information.
Un accidente sin intercambiar la información que necesitabas hacer.
We're facing up to 180 days in jail.
180 días en la cárcel por
and or a $2,000
una
fine.
multa que no sobrepase $2,000.
We are going to do probable cause.
Soldados.
You have the right to remain silent. Anything you say can or will be used against you.
Contra usted.
I insist she stays silent.
Y tu abogado insiste que se quede callado.
Just please go slow.
Yes, Your Honor. On March
El
10th,
10 de marzo
2025,
del 2025,
officers were
los
dispatched to
oficiales
Safer
fueron
Street
a
and
una calle
Prescott
Safer
Street in reference to
Street.
an MSGI.
bajo una referencia de faltar y dar información.
The officers were
Los
advised that a white Charger
oficiales
left the scene
dijeron que
following
un
an
white Charger
accident
se fue de la escena después de un accidente
and was last seen
y
going
lo
southbound
vieron
on Shaver
ido
Street.
por el camino al sur en la calle Shaver.
The complainant stated that she
quejante
was
dijo
traveling when a
que
white
ella estaba
Dodger
manejando
made a
cuando un
unsafe
Dodger
lane change
Cambió de carril, pero sí,
and collided with her.
y chocó contra ella.
The complainant
El
showed
quejante
officer a
dijo,
picture of the
Él
suspect
tomó
vehicle,
una foto del vehículo y le enseñó al oficial
showed the license
y
plate,
enseñó, tenía la
and
placa.
damage to the vehicle
y
in
el
the back
daño al
left
vehículo.
portion. The complainant
El
estimated that the
quejante
damage was
dijo que
around
le
$1,000.
está estimando que costó como $1,000 en reparación.
Officers ran the
Y los
vehicle and
oficiales
found the registered
Dieron la
owner to
placa
be
y
Juan Manano.
encontraron que el dueño era Juan Meneo.
The officer located the vehicle at the apartment complex
Encontraron
that the
el
vehicle was
vehículo
registered to.
en los apartamentos a donde estaba Ricky.
And just like that, we shift gears from guns to fenders. The next defendant faces a totally different kind of trouble, a hit and run. But even in small cases, details matter, and this one's about to test how far probable cause can stretch.
The officer met with
Y
Juan
el
and his
oficial
wife, who
habló
is the
con Juan
defendant.
y la esposa, que es la acusada,
Juan advised the officers that the
y Juan le
defendant had been
dijo
driving the
que la
vehicle all
acusada
day,
estaba manejando todo el día el
and
vehículo,
that the only damage to the
que
vehicle should have been on the front bumper from a
que tenía
previous
el
incident
vehículo
and
era en
nothing
la
else.
parte de frente de un accidente previo.
The defendant advised
el
the officers
acusado
that she was
le
driving the
dijo
vehicle and
que
had
ella
recently
estaba
gotten back from a Walmart,
el vehículo y había regresado
which
de
is around
Walmart,
700
como
feet from where the
700
incident occurred.
pies de donde ocurrió el
She denied hitting
incidente,
anybody.
y ella negó pegarle al negó que
Your Honor, so based on the
y
information,
basándome en la
the
información de ese
car was registered to his wife.
So, how do we know
And
who's driving
the
it?
complaint,
y
the
cómo sabe quién estaba
Juan stated
manejando.
that he was the one driving and she admitted to being in that location at the time.
She denied hitting, right? Do we have any kind of evidence that puts her at the scene that she's the one that causes the accident?
Que ella estaba ahí y causó el accidente. Go ahead.
That she was the one within 700 feet of the accident and that she had access to the vehicle, Your Honor.
Tenía acceso al vehículo y estaba a 700
And this
pies
vehicle was the one that was in the
del lugar.
accident.
Y ese fue el vehículo que estaba en el accidente.
Did you say that the husband said that she was driving it?
She was driving
El
it all day.
esposo dijo que estaba manejando. Dice que sí.
Do you want to add anything? Did you want to say anything?
No, well,
Yeah,
two
yeah,
things, Judge. Number
yes,
one,
of
there
course.
was no evidence that
No
she
hay
was,
evidence.
as you mentioned, there was no evidence that she was
Yeah,
driving the
yeah.
vehicle. And just because she had the vehicle all day does
Solo
not mean she
Dice
was
porque
driving
tenía
it.
el vehículo ese día.
For example,
No
when I'm
significa
sure my
que
daughter's
estaba
home,
manejando.
I'm sure,
Porque, por
and she's using one of our vehicles, I'm sure that
Mi hija
her lunkhead
estaba
boyfriend is probably driving it the majority of the
vehículo
time.
puede ser que
Additionally,
el
this
novio de
vehicle
mi hija
is
estaba
insured.
manejando.
Quick legal tip: when the judge keeps pressing for evidence linking the driver to the scene, that's the essence of reasonable doubt. No video, no eyewitness, no confession, just assumptions. And in criminal court, assumptions don't stick.
Ahora, el vehículo
There's
está-
never been
tiene
any
su- está
report
seguro.
of anyone,
Y
but
no hay
people had
report.
consent to driving it. That defense is not going to be erased, so this is an
Yes, sir.
insured incident.
It's just
Es un incidente.
we got A, we got C, but you don't have B. I mean, I just don't think that,
A ver,
officer could have gone to Walmart, pull video, see her coming out, other
pueden ir a Walmart a ver si
cameras anywhere else. I don't know, but I just
no hay
I
pruebas.
don't think there's enough.
Okay. Sure.
All right, I'm gonna find no probable cause in your case, man.
A encontrar que hay motivos fundados para mantenerte.
Please be careful when you're driving.
Ten cuidado con
If you're going to drive, do not drive unless you have a valid license
no manejes
and liability insurance in your name.
y seguro.
Do you understand?
¿Entendido?
Okay, all right.
And she does, for the court's edification.
Thanks, Jen.
Always great seeing you, and I apologize on the record for calling it my future son-in-law is a lunkhead, in case that goes anywhere. I forgot it's being videoed. All right, take care.
That last exchange? Classic courtroom humor. Even judges need comic relief after sorting through half-baked police reports. But it also highlights something deeper. Justice isn't just about guilt or innocence, it's about how carefully we demand proof before passing judgment.